Belize National Prayer. Almighty and eternal God, who through Jesus Christ has revealed your glory to all nations, please protect and preserve Belize, our beloved country. God of might, wisdom, and justice, please assist our Belizean government and people with your Holy Spirit of counsel and fortitude. Let the light of your divine wisdom direct their plans and endeavors, so that with your help we may attain our just objectives. With your guidance, may all our endeavors tend to peace, social justice, liberty, national happiness, the increase of industry, sobriety, and useful knowledge. We pray, O God of mercy, for all of us, that we may be blessed in the knowledge and sanctified in the observance of your most holy law, that we may be preserved in union and in that peace which the world itself cannot give. And after enjoying the blessings of this life, please admit us, dear Lord, to that eternal reward that you have prepared for those who love you. Amen. Amen.
Oath of allegiance of a new senator.
Deputy Clerk, kindly administer the oath of allegiance to the new senator.
I, Elma Kay, do solemnly and sincerely affirm and declare that I will bear the true faith and allegiance to Belize, and will uphold the Constitution and the law, and that I will conscientiously, impartially, and to the best of my ability discharge my duties as a senator and do right to all manner of people without fear or favor, affection, or ill will.
Congratulations to you, Senator Dr. Elma Kay, and welcome to today's sitting.
Announcement by the President.
Good morning. Today, I am most delighted to congratulate two Belizean athletes whose performance captured the hearts of all Belizeans over the past couple weeks. First, Oscar Curious Jr., the winner of the 139.9 miles Holy Saturday Cross Country Classic race. He did it in 5 hours, 43 minutes, and 19 seconds. We all had a lovely Easter vacation. And second, 14 years old, Dimitri Myers, who made history in capturing for Belize gold in 2 races, the 1,500 and the 3,000 meters race at the Carifta, the 50th anniversary Carifta Games. To both of them, we are also very proud of you. Honorable members, by letter dated 24th March 2023, Cabinet's recommendation has been signified to the Nonprofit Organizations Bill 2023.
Bills brought from the House of Representatives.
I recognize the leader of government business.
Madam President, I rise to take charge of the following bills: Legal Aid Bill 2023, Extradition Bill 2023, and Non-Profit Organization Bill 2023. Madam President, in accordance with Standing Order 49, I move that the Legal Aid Bill and the Non-Profit Organization Bill 2023 be taken through all their stages forthwith.
Honorable members, the question is that the bills be taken through all their stages forthwith. All those in favor, kindly say aye. Those against, kindly say no. The ayes have it.
Motions relating to the business or sittings of the House.
Madam President, I move that at its rising today, the Senate will adjourn to a date to be fixed by the President.
All those honorable members, the question is that at its rising today, the Senate adjourn to a date to be fixed by the President. All those in favor, kindly say aye.
Aye.
Those against, kindly say no. The ayes have it.
Public business, government business, bills for second reading.
Madam
I
President,
recognize the leader of government business.
Madam President, I rise to move a second reading of a bill for an act to amend the Senior Courts Act Number 27 of 2022 of the Substantive Laws of Belize to remove provisions relating to the assignment of attorneys at law by the court, to provide legal aid services, and to provide for matters connected therewith or incidental thereto. Madam President, you will recall, and senators will recall, that at our last meeting, we deferred debate on this bill in order that it could be debated with the legal aid bill. So with the leave of you, Madam President, I would like to move the second reading of the legal aid bill as well so that they can be taken together. I rise to move the second reading of a bill for an act to make legal aid readily available to persons of small or moderate economic means, to enable the cost of providing legal aid granted to persons of small and moderate economic means to be defrayed wholly or partly out of money provided for that purpose by the National Assembly, and to provide for matters connected therewith or incidental thereto. Madam President, in very brief remarks, may I first of all welcome Senator Kay to today's Senate meeting, and secondly, to say that we look forward to her continued contribution during the debates, particularly on the non-profit bill. Madam President, the legal aid bill is long overdue. The amendment to the Senior Courts Act simply removes the power of the court to assign attorneys at law to legal aid cases. The legal aid bill for itself advances legal aid substantially in Belize by the creation of a commission that deals with the whole question of legal aid and sets out all the functions and composition. Madam President, I would signal at this stage that in the committee of the Senate, I propose to move an amendment to Clause 6 of the bill. In the exercise and performance of its functions under this or any other law, the Commission shall act in accordance with any general directions of the Minister. I'll propose that we delete that, and so that the clause would read, in the exercise and performance of its functions under this or any other law, the Commission shall, when exercising and performing its functions, be subject to the control or direction of no person or authority. You are going to propose that? Sorry. Madam President, the Commission, as you see, is appointed by the Chief Justice in Clause 5 and reflects different persons in the association, in the legal profession, as well as human development or social welfare. The duties of the Commission are set out, and the extensive powers of the Commission appear in Clause 8 of the bill. And essentially what it seeks to do is to empower the Commission to administer a comprehensive legal aid scheme for those who require legal services but are unable to afford it. The director is appointed by the legal aid The Commission appoints a director, and the Commission may appoint and employ as temporary or permanent staff at such remuneration as they may think fit the legal officers, employees, etc. of the Commission. The director of the Commission, of the Legal Aid Commission, is set out in Clause 11, and Clause 12 provides for attorneys at law to voluntarily offer themselves to provide legal aid services, and a panel will be prepared in that regard so that cases can be assigned to them. Madam President, under Part 4, a full regime is set out as to how the legal aid will be financed and how certificates may be applied for by persons who want legal aid and how they are to be granted. It is very comprehensive and is much of an improvement on what we have at the current time, which is largely unregulated by a comprehensive act. Clause 21 provides for students of the law to assist and to provide legal services under the supervision of a qualified attorney at law. And finally, Madam President, Part 6 provides the customary financial provisions for any entity that is set up. In this case, the Commission is required to prepare its budget, etc., submit it to the Ministry of Finance, receive its monies, audit its account, provide an annual report, etc., etc. Madam President, we commend the legal aid scheme to this Honorable Senate.
I recognize Senator Michael Purfeet.
Thank you, Madam President. And let me join, I would say, all of us in welcoming Senator Key, Dr. Senator Key, classmate from Sixth Farm. Yes, we have done well, you know. We have done well. We've done well. We have done well. Madam President, I think one of the main mischiefs that I hope can be cured when rules and regulations are set for legal aid going forward is this. And I see that there is a simple application under Section 12 that says that if an attorney's name is on a panel, so clearly as I understand it, the Commission would designate, okay, these are 10 attorneys, these are some attorneys, these specialize in civil matters, criminal matters, whatever. And an attorney whose name has been listed in any panel may at any time request that his name be removed from any panel and the director calls the name of the attorney at law to be removed. Madam President, one of the major problems we have with legal aid is this, and it caused a lot of backlog for those people who genuinely need legal aid. In the criminal law aspect of the practice, you would have certain people who would purposely not seek to hire an attorney because they know one for sure will be assigned to them, so they just wait, and they figure their case will take about 5 years to begin anyway. I think the appointment of a commission kind of gives some teeth to the whole concept of, listen, we're going to do it in an organized way to determine who really can't afford an attorney. What I hope to see accomplished, Madam President, is when attorneys are assigned matters, and I can personally say I used to bear the brunt of this because I started off doing criminal defense. Attorneys will be assigned a matter by the Chief Justice as the law was back then. And then an attorney would say, well, I don't do criminal law, so I have to be excused from that case. I have never done a murder case before. And so they would take all these free cases practically and put it on attorneys who only practice criminal law. Well, I used to say, Well, before I did my first murder case, I didn't do a murder case either. I mean, you have to take responsibility. I would hope that it will be very difficult once the commission assigns you to do a particular case that you can't just say, I don't do that type of law. You can't just request your name to be removed. It has to be that if you are assigned a case and you don't want to do that case, then it is up to you to pay another attorney a fee for that other attorney to take it up on your behalf, and that way you would have done your duty in terms of saying, look, I don't do that case, but I have some other lawyer who will take my place. I think it has to be, and as they develop rules and regulations, I hope that they take the opportunity to make it next to impossible for an attorney to just pass up that responsibility. But other than that, Madam President, I think the whole concept of doing something like this is a good concept, and we will see how it plays out. Thank you, Madam President.
I recognize Senator Dr. El-Makey.
Madam President, I rise on behalf of the NGO sector to make my comments on the Legal Aid Bill of 2023, and I ask your kind permission to refer to my notes. I want to begin by quoting opening paragraphs of an article on expanding access to affordable legal services in Belize through the Legal Aid Center that can be found on the UNICEF website. In a developing country such as Belize, access to services is a constant challenge for people with limited financial resources. For many families, paying for competent and qualified legal assistance, regardless of circumstances, is simply not an affordable option. Established in 2002, the Legal Advice and Services Center exists to provide legal aid to those who do not have the means to hire a private attorney. With only 4 full-time lawyers and 3 support staff, the agency headquartered in Belize City struggles to meet demand. However, the current roster of attorneys represents a 4-fold increase in human resources. For the first 7 years of operations, the center only had 1 lawyer to serve the entire country. I also quote the United States State Department Belize 2022 Human Rights Report at page 6, Trial Procedures, where it says, the law provides for the right to a fair and public trial, and the judiciary generally enforce this right, although delays in holding trials occurred. There is no requirement for defendants to have legal representation except in cases involving murder. The Supreme Court's registrar is responsible for appointing an attorney to act on behalf of indigent defendants charged with murder. The Legal Advice and Services Center provides legal services and representation for a range of civil and criminal cases. These legal aid services were overstretched, however, and were not available in rural areas. The Human Rights Commission of Belize continued to raise concerns that several immigration offenders remained in prison despite paying the necessary fines and completing their prison sentences. Madam President, I cite these existing reports because we do not think it can be overstated how critically important the work of legal aid services are to this country. Our citizens, no matter their economic circumstances, have the right to justice. Based on just these 2 reports, it is imperative that we set out to create an environment conducive to encouraging those who require legal aid to seek it out. We do have some concerns that some aspects of this bill would discourage rather than encourage access to legal aid because of the overall wording. Clients will still need to be vetted and based on financial assessment will be put on a payment plan. Is it that the practice has been that legal aid has been manipulated by those who can afford legal services? We also note that this bill proposes to set up an autonomous corporate body, the Legal Aid Commission. But we signal from now that if the commission is not allocated the appropriate financial or expert resources, or if the resources are somehow to come from those that desperately need the legal aid, then the exercise is futile because it will not actually ensure that those who require justice have access to justice. So we confess that we are grappling with the fundamental differences set out in this bill that will enhance and increase the current services for legal aid. Madam President, we also wish to be guided on how this proposed legislation will benefit the Belizeans and all those who depend on such services moving forward. Again, we quote the UNICEF report, Belize law only requires a pro bono lawyer to be provided when a person is charged with murder. Even then, the attorney is not assigned until the trial phase of a case begins. While the Legal Advice and Services Center is tasked to represent some of the people accused of murder, the judiciary may assign those cases to other private attorneys. Clients who seek help from the center have needs that range from matters such as divorce or estate planning to child custody and maintenance issues to criminal offenses. And there's a small consultation fee is charged, a fraction of what a private attorney may demand. To prevent abuse of the systems, all clients are subjected to a means test to determine whether or not they could afford a private attorney. The report goes on to call out the importance of setting up legal support to ensure juvenile justice, including addressing child abuse cases without the fear of stigma via mobile clinics where a range of issues, everything from wills to land titles and serious issues, can be handled. So again, Madam President, this is the situation that frames our intervention to this bill. Let us be clear as to the need for us to do everything possible to strengthen legal aid so that the most vulnerable in our society can access the justice they deserve.
I recognize Senator Eleanor Smith.
Thank you, Madam President. Good morning. Few comments on this bill on behalf of those I represent. Firstly, I want to express appreciation, Madam President, for the amendment that was made in Clause 6. I know that we keep referring to the discretionary powers that we keep giving to ministers. And there are some boards that are indeed that must be independent as can be, and this is one such board. And so I appreciate the change that was made here to ensure that this body is indeed or should be independent, as was mentioned by the leader of government business. At Clause 12, the appointment of attorneys, I think we understand that there is already a shortage of legal persons, of attorneys. And one of the concerns that we have, that we wish to express here, Madam President, is whether we may see less persons willing to be on this panel, to be available, and what impact that would have on those persons who are waiting trial. Because, sometimes, people, it takes some time sometimes, and people are on remand for quite a long time. And this may be, I'm not of the system, so I'm just sharing, what we perceive to be, or that could possibly be a holdback. That maybe persons might have to wait longer to be able to get a representative or someone to represent them. I know that Senator Perry-Fitz and Senator Kay just now shared about whether these persons, some persons may be using this system to their advantage. And so we have to pay attention to how that works as well. But we just want to caution that hopefully we have enough persons who would be on the panel who would be able to offer their services to these persons who are truly in need, and that this would not end up in a case where they are on remand longer because they are unable to get someone to represent them in a timely manner. As well, we look at the 31 that speaks to reporting. Again, that is essential. It is key because we must have reports on these things. But at times, Madam President, when we put these things in place, we don't look at penalties for these things. So you are to report, but what happens if you don't report? What is there to hold persons accountable for ensuring that reports are indeed provided within the time frame and within the scope of the person's work? So yes, we must expect reports because persons must be accountable. But how do we hold them accountable in ensuring that indeed they do report? And what will be there to ensure that? These are some of the areas that we want to get some clarity or at least some assurance that these things would not have no negative impact on what it is that this bill is trying to address. And as I said, I don't have any legal background. I may have missed something, but the clarity that can be provided will help us to be able to go through. We also look at Schedule 1. The offenses that were listed there, criminal matters. And so I'm not sure, for those who are of legal background, if this would be considered limited in scope or whether other matters can be added here. Leader of government business, I await the expert response to this one. Maybe there might be other matters that can be included, or maybe the ones that speak about any other offenses would cover and would broaden it. I seek that clarity. Also, there is provision that the list can be extended. I do know that. But just in the event that maybe some of these other things were not considered when the list was being derived, I am just querying whether it could be bigger, or we feel that it covers all that should be covered at this time, and it gives a broad enough scope to be able to help these persons. And then the matter of the appointment of the director, the query was, why not go through the Judicial Legal Services Commission to do that appointment and to look at, whether this director would be subject to those provisions under that commission, and whether this person would be on contract. How would this position be dealt with in terms of the person's employment, appointment, and those areas? So those are some of the questions that we'd like to have some responses to as it relates to this bill. With those, Madam President, with those being addressed or being clarified for us, then I believe that we will be able to support this bill. I thank you.
I recognize Senator Isabel Bennett Moody.
Morning, Madam President. Morning, colleagues. Just a few comments as I rise to support the Legal Aid Bill 2023. This is yet another milestone for this government in supporting Belizeans overall. We do know and understand that there's a large portion of our population that does not have the financial resources nor the educational background to be able to navigate the justice system. So having a legal aid bill and all its framework do afford for thousands who are at risk of having their rights ignored or violated, especially when they're interacting with the criminal justice system. They now have an avenue to be able to, for their rights to be protected. This, therefore, to my mind, translates into Belizeans having access to justice, whether they're poor or marginalized, or whether they're at disadvantage in accessing the system. I also like to make the very salient point, though, that this legal aid bill actually supports the 2030 Agenda for Sustainable Development, which is Goal 16. It's about promoting the rule of law and ensuring equal access to justice for all. So this bill, the Legal Aid Bill 2023, is the element of access to justice, and it speaks to the heart of equality and equity in our Belizean population. I support the bill.
I recognize Senator Bevin Carl.
Thank you, Madam President. Madam President, I rise in support of this legal aid bill. Madam President, it's no secret that the legal needs and the legal services available in Belize has a huge gap, Madam President, and this gap needs to be closed. This gap, Madam President, not only mostly affect those living in poverty, but it also perpetuates poverty, and this needs to be addressed, Madam President. Studies have shown that without access to legal advice, many of our Belizeans are unaware of their legal rights and their potential claims. Studies have also shown, Madam President, in Belize and across the Americas, that about 80% of the civil legal needs of the marginalized go unmet, and up to 40 to 60% of the middle class also go unmet, Madam President. So this is speaking volumes, and I'm happy that this administration is looking into this, because access to justice is now critical, Madam President, and making justice equal for all Belizeans, regardless of their economic status, is a priority for this government, and I'm glad that, again, this bill is seeking to address this gap and also giving access to our marginalized Belizeans their rights as a Belizean and as a human being. I support this bill, Madam President.
Madam President, I thank the senators who have contributed to the debate. First of all, Madam President, this is an improvement on the current situation. There is no legal framework that exists for legal aid in Belize other than the power of the court to make an assignment for a criminal matter. Now, there are a number of competing things which Senator Perfit alluded to. The first thing is we have to bear in mind that this is a country of laws. You cannot, regardless of your profession, I cannot send somebody who wants some planning work done and say, go to Madam President, I know she's a planner and she will do it for free. I can't send somebody and say, go to a doctor and tell the doctor to provide an operation for you, and he or she will do it for free. Nor can I say, I want to build my house and go to a politician and say, do you know any contractors? Tell them to build my house for free. In similar vein, you cannot send somebody to an attorney's office and say, you go and do this case in court and do it for free. That having been said, all senators who spoke, and I believe all Belizeans will appreciate, that we understand in a society that is ruled by law, the judicial system can only work if most litigants have access to affordable legal aid, affordable legal services. So the first principle is, if you can pay for it, you pay for it. The legal aid scheme, the legal aid services, does not exist to allow persons who have the ability to hire Senator Perfit to come and say, I want legal aid and the state must pay for me. So Senator Perfit made the point, and I agree with him, and I think there is provision in the bill that seeks to ensure that the legal aid scheme that is being developed does not prejudice private practitioners. Madam President, there are instances of persons who are paying lawyers. They can afford the service. Halfway through their matter, they hear that legal aid exists. They go to legal aid and say, I need help. You have a case. Okay, tell me your papers. You tell the papers, and then they get that service at the much discounted cost paid for by the taxpayers of this country with very little contribution from them if they say they have money. The long and short of it is there are far more people who cannot afford legal services, and those are the persons who this scheme seeks to cater to. You cannot afford a private attorney. We will provide the process for a means test so that you can get legal aid through the commission. Now, a number of things. Clause 4 says that the commission is going to be an autonomous body. And I believe, Senator Smith, that is why the director is appointed by the commission rather than the Judicial and Legal Services Commission, i.e. this autonomous body has the power to hire, fire, set the terms and conditions for its employees. Secondly, under Clause 5, the expectation is that 5(1)(e), a member nominated by the minister responsible for human development and social welfare. The purpose of that is clear. When one looks at the means test, when one looks at the assessment that has to be done as to whether or not a person does qualify and is in true need of legal aid services, a social worker or some person trained in social work is going to be an asset to provide assistance to the commission, and particularly in preparing the forms, preparing the means test, preparing the procedures and regulations that have to be promulgated in order for this scheme to work successfully. In relation to one of the comments raised by Senator Kay, you will see at Clause 7(e) a duty on the Commission to organize the establishment and operation of offices and clinics to provide legal aid services throughout Belize. And so there is an obligation on the Commission to go to the people, if you will, in the delivery of legal aid services. Madam President, again, just to make a point, under Clause 8, H, the Commission will establish a roster of attorneys at law or other persons for the purpose of providing legal aid services under this Act. And as we have already discussed, Clause 12 provides for the preparation of panels. So a panel for criminal matters, a panel for civil matters, a panel for appellate matters. Persons volunteer and put themselves on those panels. It is important, Madam President, to recall that in addition to those persons, the Legal Aid Commission itself and the director will have their own in-house attorneys at law available to assist, to provide representation. So you will have persons on staff who provide representation, but in addition to that, you go into the private sector and say, will you be prepared to take 1 or 2 cases per year as a contribution to the society on legal aid in a civil matter, in a criminal matter, in an appellate matter? We will put your name on the list. We'll call on you once or twice a year, or 3 times a year, as the case may be. One of the points that is also made by criminal practitioners in particular is that they are prepared to take more criminal work for indigent persons, and persons who cannot afford the commercial rates. But first of all, the fee that is currently paid is low and it's capped. So you go and you say, I will take this murder case. They say it is going to last a week, and 3 weeks later, you're still in court and the fee is capped. You can't get an increase that is 3 times the period that you expected to be away from your practice. So there's a different system that is being introduced that will allow a fair remuneration for persons who volunteer to do the legal aid services. Madam President, in addition to that, just a couple other things I wanted to respond to before I ask that the question be put. Clause 20 of the bill, I think, is also important. Clause 20 says, where a legal aid certificate is granted pursuant to Section 14, the director may act for the aided person, that is, somebody from legal aid will represent, or may assign an attorney at law on the panel of attorneys, factoring the wishes of the aided person, and in such a case shall endorse on the legal aid certificate the name of the attorney at law so assigned. So once a certificate is granted, they might decide that, listen, Senator Perry is good at this type of case. He's on the panel, assign it to him rather than have somebody in-house, so that the director has that flexibility to ensure that the services are provided to persons who need the services. In addition to which, and I want to emphasize this, Clause 22, where a court is satisfied that in the interest of justice, another member of the panel of attorneys ought to be appointed to provide legal services for the person to whom a legal aid certificate is issued, it shall so direct. So the matter may be before the court, and as Senator Perry was saying, a junior attorney may be assigned the case, and the judge looks at this case and realizes, hold on, this young attorney is not experienced enough to handle it. I will issue an instruction that an additional attorney with more experience be brought in to provide the assistance in order that the person's case is not affected by that. Finally, Madam President, there is Part 1 of Schedule 1, the question of the offenses. Any capital offense, manslaughter, rape and marital rape, all indictable offenses where the person charged is a minor, so minors will be guaranteed representation by legal aid for any indictable matter. Any indictable offense, the trial of which is certified by the trial judge to be or as likely to be of difficulty and to require the assistance of an attorney at law on behalf of the person charged therewith for its proper determination. What is that saying? The trial judge on any indictable matter will simply say, this case, you will not be allowed to come before my court without representation. I will instruct that legal aid provides an attorney for you. So you could have gone and sought legal aid representation. If you were not aware of that and you appear before the High Court and the judge sees the nature of the case, the judge can say, I will give the instruction that you get the legal aid that you require. The same applies on the F for appellate matters. Madam President, at this stage, the list should not, in our view, be extended at this stage. There are a lot of cases that fall into these categories. The system cannot be overtaxed when it begins. As Senator Smith pointed out, the list can be extended at a later time. And finally, Part 2 of Schedule 1, the civil law matters, family law proceedings, civil matters involving minors, habeas corpus, estate matters, and, as mentioned by Senator Kay, matters relating to land. So this is a comprehensive criminal and civil legal aid scheme that is expected to provide legal aid to persons who are in need of legal services but who cannot afford it. Madam President, I ask that the question be put. Sorry? Yes. Senator Elena Smith is reminding me of her question of the reporting, which is traditional for all of these statutory bodies. Madam President, I share her concern. I would be reluctant for us to amend the bill to provide for some sanction for a director or a commission that does not report. If we do that, we have to do that for all the statutory bodies across the country. And I think we should only do that after some serious and mature consideration as to what would be the appropriate sanction, what are the difficulties why reports are not being made, how can we ensure that tools are given to persons to ensure that they can make their reports on a timely basis, and if they fail, then there would be a sanction. But I think rather than to do it right today and now, I would propose that we have a more sober and mature discussion on that issue. But I do recognize and share her concern. I ask that the question be put. Sorry?
Honorable members, the question is that the bill for an act to amend the Senior Courts Act, Act number 27 of 2022 of the substantive laws of Belize, to remove provisions relating to the assignment of attorneys at law by the court to provide legal aid services and to provide for matters connected therewith or incidental thereto, be read a second time. Honorable members, the question is that the bill for an act to make legal aid readily available to persons of small or moderate economic means to enable the cost of providing legal aid granted to persons of small and moderate economic means to be defrayed wholly or partly out of the money provided for that purpose by the National Assembly, and to provide for matters connected therewith or incidental thereto, be read a second time. All those in favor, kindly say aye. Aye. Those against, kindly say no. The ayes have it.
Bill for an act to amend the Senior Courts Act, Act number 27 of 2022 of the substantive laws of Belize, to remove provisions relating to the assignment of attorneys at law by the court to provide legal aid services and to provide for matters connected therewith or incidental thereto. Bill for an act to make legal aid readily available to persons of small or moderate economic means to enable the cost of providing legal aid granted to persons of small and moderate economic means to be defrayed wholly or partly out of money provided for that purpose by the National Assembly, and to provide for matters connected therewith or incidental thereto.
I recognize the Leader of Government Business.
Madam President, as I had indicated to you and to honorable senators, I will ask that we defer the second reading of the extradition bill to allow us to consider the bill and to make some amendments.
Honorable members, the question is that the bill be deferred to a further date. All those in favor, kindly say aye. Aye. Those against, kindly say no. The ayes have it. I recognize the Leader of Government Business.
Madam President, I rise to move a second reading of a bill for an act to provide for the regulation of non-profit organizations, to protect non-profit organizations from terrorist financing abuse, to satisfy the requirements of the Financial Action Task Force recommendations with respect to laws regarding combating the financing of terrorism, and to provide for matters connected therewith or incidental thereto. Madam President, the Non-Profit Organizations Bill 2023 has undergone substantial amendments after consultation with social partners. This bill, as senators are aware, is required for us to meet our obligation under the review of the Caribbean Financial Action Task Force. Madam President, with your permission, I will ask Senator Koi to introduce the proposed amendments to the bill.
I recognize Senator Chris Cowie.
Thank you, Madam President. Before I go specifically through each of the proposed amendments to the bill that has already been passed by the House, I just wanted to give a little bit of context. Specifically, the NPO bill forms a suite of legislation that are being proposed so that we meet technical compliance with the FATF 40 recommendations, FATF being the Financial Action Task Force, their 40 recommendations, and the 11 immediate outcomes. What that really speaks to is a process in which Belize is currently engaged. That process really started December of last year with the on-site visit by the Caribbean Financial Action Task Force in December of this year. But as part of that process, or in that process, Belize will be evaluated on two main components. One is technical compliance, and the second is effectiveness in enforcement of our laws as it relates to anti-money laundering, terrorist financing, and proliferation financing. Now, these are some heavy issues that we have to address, and it's a tall order on Belize, a small country, a small government. But at the same time, the importance of meeting compliance, both in terms of the technical compliance as well as effectiveness, cannot be underscored enough. We have gone through this process before. There was a third round mutual evaluation process that occurred back in 2013 or thereabouts, and Belize failed. Belize failed, and what was the result of that failure? There were the FATF to its members suggested that countermeasures be undertaken. The effect of those countermeasures, it's not a coincidence that in that same time period, Belize lost over 80% of its correspondent banking relationships, the domestic banks. Belize was the most effective in the entirety of the Caribbean as far as the loss of correspondent banking relationships. And what is the impact or effect of that is that we cannot engage in cross-border business. If we lose more of that, that's the exposure that we get, that we have. Belize does a lot of its trading with the US, with EU, whether imports or exports. And to the extent of our loss of correspondent banking relationships, that is severely stifled, and that has a severe adverse effect on our economy as a whole, down to the individual citizen. So it's very important that we go through this process, as laborious, as difficult, as onerous as it might be, with the intent to meet compliance with these recommendations and outcomes. The bill, the non-profit organization bill is among the first of the laws that we are in the process of enacting with a view to meet compliance. I think the extradition bill is also one of those laws, and there are amendments to the Money Laundering and Terrorism Prevention Act that are effectively required, and as well as a number of the financial legislation that currently exists, including the Central Bank Act, the Domestic Banks and Financial Institutions Act, the International Banking Act, the Money Lenders Act, the National Payment Systems Act, the Credit Unions Act, the Financial Intelligence Unit Act, the Insurance Act, among others. We don't have much time. All of those laws have to be amended so that the FIU is in a position to submit information for technical compliance by June the 2nd. So we really only have roughly 1 month. The NPO bill, I think, has gone through a process. It was tabled on March the 10th, and I believe it was somewhat hastily done, but given the limited timeline, And I believe that there were concerns about the need for deeper or far more deeper consultations. That involved, subsequent to that, through the Social Partnership Advisory Committee, having consultations with our social partners and stakeholders. Through those consultations, and separately as well with members or the representatives of the NPO community, a number of amendments to the already House-approved bill were discussed and agreed to be submitted here before the Senate. And this is where I will get through and go through some of the discussions on the proposed amendments. In Section 2, there are several amendments to the bill, which are about definitions, who the director of the Financial Intelligence Unit is relative to the FIU Act, the Director General of the Financial Services Commission, the FIU, the Financial Services Commission, and the General Fund. Those are simply to make it easier in terms of the rest of the bill, as those persons are referred to in the bill itself. As far as the General Fund, what this seeks to clarify is that any fees collected by the NPO registrar will be paid into the General Fund, not the Consolidated Revenue Fund. That General Fund is a fund established under the Financial Services Commission Act. Just a point of clarification, attorneys might appreciate that the Financial Services Commission Act that's in the revised edition 2020 has been repealed and replaced by a new Financial Services Commission Act that was gazetted in April 15th of this year. It was passed through the House and Senate and gazetted in April of this year. That is the act that we are referring to, and the general fund that is established under that act. Section 3, whereas under the bill that came up from the House, the bill did not specify who would be the NPO registrar. This, we've gone a step further in specifying who the NPO registrar is and will be once this bill is passed, and that's the Director General of the Financial Services Commission. The Director General of the Financial Services Commission, by virtue of an amendment to the NGO Act recently, is now the registrar for NGOs. The Financial Services Commission has the capacity and the competency to serve as the NPO registrar. It has the financial wherewithal as well to serve as the NPO registrar, which is important for purposes of the FATF recommendations that are applicable. So it was felt that that would be the best party or office to serve as the NPO registrar, and that was one of those that we discussed at the SPAC meeting and was agreed. So that's Section 3.2. Throughout the bill, there were references in terms of the NPO registrar and making sure that it's a suitably qualified person. Well, clearly the Financial Services Commission and the Director General would be a fit and proper person. Section 3, subsection 3, speaks to the NPO registrar being able to appoint an assistant registrar as well as a deputy registrar. Well, subsection 2 talks about the deputy registrar. This arose out of discussions with the Financial Services Commission in terms of functional operations of the company's registry that they currently are responsible for. It was determined that having a deputy registrar and having assistant registrars to assist enabled the registry to operate more efficiently. In the case of the NPO registry, my understanding is that there are easily over 800 NPOs in existence, most of which are actually not registered with the FIU currently. And that is one of the big problems that we are currently facing with the existing legal framework as it relates to NPO, that the rule is in breach, not the exception, of the current existing laws under the MLT, the Money Laundering and Terrorism Prevention Act. The NPO bill is intended to address not only technical compliance, but the ability to meet enforcement effectively. The FATF recommendations, in particular recommendation 8, is specific to NPOs and provides for a more simplified process for set of responsibilities as far as AML, CFT, and proliferation financing is concerned. Currently, you have NPOs treated essentially in the same way legally as banks and financial institutions. So that means that you have all NPOs are, they're required to be registered currently with the FIU, but beyond that, they have significant due diligence obligations, if like a know your customer obligation that pertains to banks and financial institutions. So every customer, the NPO is obliged to maintain record keeping, due diligence information on. Now that would, if for NPOs, that is certainly very onerous. But in terms of recommendation 8, actually the provision recommendation 8 of the FATF says that say for special instances, customer due diligence actually is not required for an NPO. So this process established by the NPO bill seeks to reduce the set of obligations that currently exist under the Money Laundering and Terrorism Prevention Act and replace it with what's in the NPO bill, a much less set of obligations for the NPO, both in terms of transparency and accountability. Getting back now into the registration process in the bill and the amendments proposed, the further amendment in Section 3 is in terms of the registrar, that no liability attaches to the NPO registrar, provided that NPO registrar acts in good faith. In the bill, what we had in terms of the House-approved bill was a level of discretion that existed for the NPO registrar or the minister by providing for the minister may or the NPO registrar may. So in the discussions at the SPAC meeting, where possible, the preference was that any recommendation by the Commission or the National Anti-Money Laundering Committee that is made, the minister or the NPO registrar, as the case may be, shall, rather than have discretion, that they shall exercise in accordance with those recommendations. So that was agreed, and so you will see throughout the bill, the amendments proposed is that shift from may to shall. So in the case of Section 3A, 3A is an innovation in that it provides for a committee to be established that includes stakeholders from the NPO community. In subsection 2, that committee is established in accordance with paragraph 1A as far as the NPO registrar obligations in setting up that committee, and it it provided for, it may include members as determined by the NPO registrar in consultation with the National Anti-Money Laundering Committee. That amendment is to move from may to shall. So as a matter of certainty, those members will be form part of that committee as in consultation with the NAMLAC. Subsection 4, I think that really is more of a typo to shift from or to and. From here, we move further down to section 6, subsection 2, as far as an application being accompanied with by the required fee. This is a prescribed fee that would be set out in the regulations to be forthcoming. So it was just a matter of clarifying that provision. Section 6, subsection 6 speaks to where the fees are to be paid, and as I had mentioned at the outset, those are now to be paid into the general fund of the commission as opposed to the consolidated revenue fund. They are the responsible party. Section 6, subsection 5, refers to the introduction of the phrase cessation of the operation or non-existence before the word non-existence. That, again, is more for clarification. The initial part of subsection 5 spoke about cease to operate. So at the end, it's just to make sure it's referring to that. Section 7, subsection 1, proposes, again, this is more in the nature of a clarification as to how NGOs that are registered versus NGOs that are not registered, who are captured by this NPO bill, and this makes sure that it is a broad capture of both NPOs that have been registered and NPOs that have not yet been registered. Section 7, subsection 3 and 4, those again are mere typos. They reference to the section in the Money Laundering and Terrorism Prevention Act. Section 2 is incorrect. It should be section 85B. Just as that shift from may to shall throughout the bill, there is also references to insertions of the phrase in writing, wherever notifications are to be given or communications are to be given with the SPAC and the NPO community. The preference is that those be reflected in writing, and so those insertions are placed throughout the bill. Section 8.1, subsection B, the edit to the subsection is to align with the current provisions in the Belize Companies Act. In the Belize Companies Act, as opposed to how it was in the House Approved Bill, the House Approved Bill had the name of the nonprofit organization is offensive to good morals. That left a lot to interpretation, and the preference was that there is clarity and consistency with what is in the Belize Companies Act. So that is what this amendment is about. The name of the nonprofit organization is offensive or for any other reason objectionable. That is how it is reflected in the company's law. A minor insertion in subsection F of section 8.1 is to include the term substantial, so that the non-profit organization that the NPO registrar may refuse to register a non-profit organization that does not have a substantial connection with Belize. 8.1 subsection 8, a proposed insertion is to include at the end the name of the nonprofit organization is different from the name in which the entity was established. If the entity was established as a company, partnership, foundation, trust, or other legal arrangement, the proposed insertion being at the end of that unless such an entity has a registered business name. So the NPO registrar may refuse to register on that ground unless the entity has a registered business name. There are NPOs that do have a component of that NPO that may engage in some commercial activity, the proceeds of which are utilized towards the charitable purposes that are set for that NPO. And that commercial activity may not operate under the name of the NPO, but under a business name that the NPO itself owns. So that is what this carve-out provides for. Section 8, subsection 2, there's a proposed insertion after where the NPO registrar refuses to register an NPO under subsection 1, a notification requirement that the NPO registrar shall notify the NPO in writing within 21 days from such decision of the grounds of such refusal. So the NPO registrar has that obligation and lays out what the grounds for refusal are. It enables the NPO to be clear on what relief it may seek if it feels that it is aggrieved by that decision. Section 9, there's a proposed insertion of, in terms of publication of registered names, etc., the list to be not only in the Gazette but on the Commission's website. That list also be expanded to include not only NPOs registered, but also those that have been suspended and cancelled, as well as a list of all international, regional, and international organizations exempted by the Minister pursuant to Section 24 of this Act. This would include, for example, UNDP and UNICEF and those types of internal organizations that would be exempt, likely to be exempted by the Minister. Section 10, subsection 2 is just in writing. Section 10(2), subsection C, again, a matter of clarification that the term carrying on of business is replaced with conduct of operations, so that 2C reads as observe the conduct of operations of the NPO. Section 10 is one of those sections that is a clear requirement under the FATF recommendations, recommendation 8 in particular, and I believe in connection with immediate outcome 10, that there is on-site monitoring of NPOs, and it operates in the same way the current, under the current law, that the FIO has that obligation. The Financial Services Commission also has that obligation as it relates to entities that it supervises, and the central bank also has that power and obligation as it relates to the domestic banks and financial institutions that it supervises. The Section 10(2)(e), there is a proposed amendment to remove the reference that the NPO registrar in its on-site inspection can require any person on the premises of the nonprofit organization being affiliated with the nonprofit organization to provide an explanation of any recorded information or to state where it may be found. It was felt that that was certainly way too broad a power, and that it should be restricted to just controllers of the nonprofit organization, and that was one of those amendments that was agreed. Section 11, which refers to measures imposed on breach of obligations. Section 11B was amended again for more precision, that the measures include a directive to comply with specific instructions to ensure compliance with the obligations of the NPO, that last phrase being the proposed insertion. as far as subsection D, that such other measure as may be prescribed by regulations, not just arbitrarily, but in regulations, regulations being passed as statutory instruments. Section 12(1), subsection D, is a new insertion arising out of the SPAC meeting, that the NPO registrar may cancel or suspend the registration of a non-profit organization if in any case falling under, provided that in any case falling under subsection 1, C2 or C3 as stated above, the NPO registrar shall not cancel the registration of the NPO without following the procedure set out under subsection 2. Subsection 2 lays out that procedure where the NPO has been or is liable to be cancelled or suspended. The NPO registrar shall give notice in writing to that non-profit organization at its registered office with the insertion specifying the proposed grounds for such refusal, cancellation, or suspension. Again, introducing those clauses to ensure openness, fairness in the process, and allowing the opportunity for the NPO to look for relief as it may see just in its particular circumstances. In the case of subsection 4 of that same section 12, there is a proposed insertion at the end that reads, the NPO registrar shall be required to name as respondents to an application under subsection 4 whose persons who are known to own or control the property that is the subject of the application, as well, this is the insertion, as well as the NPO and the NPO's last controller of record. I think the purpose of that is to make sure, and this came from the NPO community, that the NPOs are on record as to who are the responsible parties. A minor edit or amendment proposed is in subsection 6, that the procedure that is to be followed are the civil procedure rules of the High Court. Following that, I think section 12, subsection 14, there's a proposed amendment in terms of the definition of wrongdoing. Wrongdoing, as it came from the House approved bill, was defined to include but not be limited to what is stated in A and B. It was felt that, again, this was too broad and non-exhaustive a definition. And so instead of includes but is not limited to, that would be replaced by the word means. So it's strictly what is set out in A and B. Section 13 deals with provisions for inquiry of an NPO by the NPO registrar. To make it absolutely clear, subsections 1 and 2 really have to be read together. Subsection 1 provides for the power of the NPO register to make an inquiry, but that inquiry can only be made if subsection 2 is fulfilled. And what subsection 2 states, inclusive of the proposed amendments thereto, is that an inquiry may only be carried out for the purpose of investigating any NPO which the NPO registrar has reasonable grounds to suspect the NPO has committed an offense, that offense being under the Money Laundering and Terrorism Prevention Act or any other law in which a contravention may constitute wrongdoing on the part of the NPO. So there has to be reasonable grounds to suspect the commission of an offense before the NPO registrar can be in a position to make an inquiry. Subsection 8 of that section 13 is also proposed to be amended what that speaks to is a person appointed by the NPO registrar to conduct an inquiry shall provide a written report of that inquiry to the NPO registrar, which what is proposed to be inserted, with such information and documentation as may be prescribed from time to time. The intention here is, and with respect to this bill and more broadly, is that there will be a set of NPO regulations that will be introduced upon consultations with the stakeholder NPO community that will lay out the particulars that will be required in various instances as referred to in the regulations. This is one of those, so that in terms of an inquiry, when that inquiry is completed, that a set of information is provided in that report. That will once again enable the NPO to understand and appreciate the full particulars of that inquiry and whether any action may need to be taken on the part of the NPO if there is an adverse result. In that same section 13, a new clause is proposed to be inserted, and this relates to the previous section that looks at the subsection 12 that looks at the suspension, where a suspension occurs. So where the NPO determines that an inquiry into the operations of an NPO is required, the registrar may suspend the registration of the NPO during the period of that inquiry. A new subsection 13 is proposed to be inserted where the NPO feels that it is aggrieved by that decision of suspension. And what that section provides, that an NPO aggrieved by the decision to suspend may apply to the High Court for relief, including A, the review of such decision, B, interim measures concerning the conduct of the NPO's operations, or C, any such other or further relief as may be just. The next proposed amendment is in sections 17 and sections 18. This was on two fronts, again, moving from may to shall, that the minister shall, on the recommendation of the commission after consultation with the NAMLA, do certain actions, which includes, by order published in the Gazette, specify the threshold of donation to a non-profit organization above which the NPO shall take reasonable steps to document and keep records of the identity of the donee. This relates back to the FATF set of recommendations, in particular making sure that there is a risk-based approach, a risk-sensitive approach to the compliance systems being set in place. That risk-based approach will certainly mean that if a donation of $5 is being given to an NPO, it's very unlikely that that will have any material impact for purposes of terrorist financing abuse, for example. So that is where that risk assessment is to be conducted by the National Anti-Money Laundering Committee. On the basis of that risk assessment, they will discuss with the commission, and then the commission will make the recommendation as to what those donation thresholds will be. The minister then shall follow that recommendation in passing the regulations as far as donation thresholds are concerned. Section 18 speaks to the classes of non-profit organizations that will be required to have their accounts audited. So it's not all NPOs that will need to be audited. That again is dependent on risk factors. What are the NPOs that are at high risk of terrorist financing abuse, for example, and those will more than likely be the ones that would have to be within the class that would be subject to auditing. Also, there are provisions for reasonable measures in terms of identifying the beneficiaries. Certainly, NPOs, not in Belize but outside of Belize, have been abused in the sense of monies flowing through those NPOs for purposes of terrorism activities, terrorism financing activities. So what kind of thresholds are we to look at from a risk-based standpoint that will require that level of detail in terms of identification? So that is what this section provides for, but in the case of the minister, there is no discretion within the minister to decide what classes. It's the commission that will make the recommendation, and the minister will pass the SI in accordance with that recommendation. There is a provision in section 18(1)(b)(1)AA for a threshold being $500 or such other sum as may be prescribed from time to time. Again, looking from a risk-sensitive standpoint, the determination is that 500 is low enough a threshold, but it will go through a process with the recommendation of the commission, ultimately whether that can be increased or reduced as a threshold. But all of that would have to be done through regulations. So we move now on to section 21, subsection 5, and this is just in furtherance of the determination that the fees and penalties that come from this or received by the NPO registrar are to be paid into the general fund. So inclusive of administrative penalties, those are also to be placed into the general fund of the commission. That takes us now to, I don't have the, you have the, I think we're I have to pull it up on my phone. Do you have? You have a printed copy? Okay. That moves us now to section Section 24. Really, that's not really consequential. That's a clerical edit. So Section 25 speaks to regulations and just more particularizes what regulations can be promulgated, but that those regulations are to be made on the recommendation of the Commission to give effect to and for the better carrying out of the provisions of this Act or for prescribing anything that needs to be prescribed. There is a new section proposed to be inserted, and that relates to the authority of the Commission. When I speak of the Commission, I'm referring to the Financial Services Commission. The Financial Services Commission, as you may be aware, has its own legislation and is a supervisor of numerous legal persons and entities. That includes registered agents, trust companies, securities businesses. It's the relevant supervisory authority under the new Securities Industry Act as well. So it has numerous obligations under other laws. So what this provision seeks to do is to say that the obligations that are to be established under this bill will not limit its obligations and authorities under those other laws. So it provides that nothing in this act shall limit the authorities, powers, functions, and obligations of the Commission as set out in the Financial Services Commission Act or any other legislation for which the Commission is responsible. Finally, there is a proposed insertion, and this relates to taking account of the concerns of the religious community, the churches, coming out of the discussions or consultations at the SPAC meeting. It was felt that a declaratory provision be inserted apart from looking at developing a special legislation for the religious community. That is this proposed section 30 that states as follows: notwithstanding anything in this act to the contrary, the provisions of this act shall not be construed as restricting or limiting the free exercise of religion or the ability of any religious organization to operate, teach, speak, or act in accordance with its own faith, beliefs, and tenets. So that I think is an effort to recognize the role of the religious community and its functions and its concerns, and overall that religious freedom not be affected. So those are the proposed edits. In the body of the legislation, but there are a few minor edits in the schedules. The schedules include various forms. One of those in the schedules speaks to who are obliged to complete these declarations. And so there's an edit on page 32 in one of the schedules that states the names, addresses, telephone numbers, and email addresses of senior officers and members of the management personnel. Senior, the clarification is that senior is to insert a provision to say senior officer includes the president, the vice president, the secretary, treasurer, managing partner, managing trustee, and the like. So that is the proposed insertion to the schedule. Thank you. So I think we've gone through all the proposed amendments to the NPO bill. On a whole, as I said, it's not what we would seek to impose, but what is in effect being imposed upon us. This is in large part for us to make sure that we not only comply with international standards / commitments, but that we don't suffer adverse consequences in the event of failure to comply. So thank you very much, Madam President.
I recognize Senator Bishop Alvin Bengusha.
Thank you very much, Madam President. Madam President, let me first of all recognize, as we have done, the presence of Dr. Elma. She comes to the Senate this morning, this afternoon, and also to certainly join you in congratulating the young athlete who was successful at the CARICOM Games. I think it is very important to be able to recognize our young people and the role that they continue to play, especially in the area of sports, and the fact that they can represent us at that level, and also to be able to excel at that level speaks a lot for not only the individual, but for the entire country. Madam President, I rise to speak on and make my presentation on the Nonprofit Organization Bill 2023. Madam President, I want to make some general statements, first of all, which I believe will form the backdrop to my presentation this morning, this afternoon. And I say that this morning, this afternoon, because certainly I will use up my time. I will use up my entire time, at least for this presentation, to ensure that I assist in making the points which I think is very important. And I want to begin by perhaps at least recognizing the level of communication and consultation which took place between Senator Coy and the other persons involved and the social partners. And I say that because I think, and I continue to say that it is the type of communication and consultation, I think, that is needed at all levels when it comes to passing bills. I also want to share this morning that I think it is important to note that though there would have been communication and consultation, and it was felt that, or it was said to some extent that this communication started a couple months ago. I want to say that as the church representative, I was only, and it was after we started making some inquiries as to this bill, that it was at that point we were called to a meeting. And so, though I will appreciate that after that, we did have the level of consultation and communication that was necessary, I felt that perhaps if it was done a couple months down the road, that would have helped us even more. And I say that because, to some extent, we felt rushed in ensuring that we met the deadline for such an important bill that is before us today. And I say we felt rushed because for many of us, we do not have the kind of capability that others might have, and the consultation that others might have insofar as expertise is concerned. To a large extent, we have to rely on ourselves to put in the work in order to ensure that we make a proper presentation and suggestions to what is before us today. And so I just feel that perhaps, and I might be wrong, but I will ask the leader of government business to help me in this regard, that I felt that the body that was given the responsibility, and I gather that it was the FIU, should have done some consultations before. As I said, I might be wrong, and I can be corrected. But that body should have started consultations a long time ago and would have better helped us in that regard. And so they must take some responsibility. And Senator Coy pointed out that we are pressured to ensure that we pass what is now before us in order to meet a deadline, which is sometime in June. And fine and good. But at the same time, we were being called and putting in some hours in order to assist the government in ensuring that we did our due diligence and homework in meeting the deadline. Madam President, I stand here and I want to present and state the church's position on this bill. And it is important to also recognize the implications for the church. And when I speak of the church, I also include our schools. But I recognize that perhaps later on other persons will speak to the issue of the management of schools. But I just also want to ensure that I share that while I speak to the issue of churches, it also includes schools that the church manages. It is also important to point out that we would like to cooperate as much as possible as a body to assist the government in passing these bills in order to meet our international obligations. I must point out, Madam President, that as far as the church is concerned, as law-abiding people, we want to join the government in ensuring that we are compliant. And so we do not, and we must never give the impression that we are against anything insofar as accountability is concerned and any other obligations that we need to meet. Madam President, in the English language, there is a conjunction, but. And that but, I think, comes with a number of things. The but comes in what we see and what is presented before us as the bill. And that which, as I said, the church is impacted in many ways. Senator Koye spoke to a number of things which has been tidied up and cleaned up. But there are some things that I must emphasize insofar as the church is concerned. And I say this because I do not want to belabor the point. But when we look at a bill of this nature, we have to ask ourselves, how does the church fit into a bill of this nature? We're asked to be listed under NPO, and that which will bring us under certain restrictions, and I want to point to some of them. Under section 12.4 and 12.5, here we see that I hope I have my sections right there. Case in point, section 12.4 and 12.5, where it speaks to, I think, the controller. Am I correct? Yes. Yes, case in point, where it speaks to the controller. In the church, there is no such controller as such, in that in the church, it is the bishop and it is the head of the church that, if we should use this secular term, who is the controller. And should that person be found responsible or liable in any way, it is the controller or the bishop who is called upon to answer in that regard. And so I point that out because in other sections, section 16 and 17 of section 16 and 17 of section 2, you will find out too that when that person is found culpable, as it reads in C, D, and E, you will find that that person is hauled before the court. And that person, it is also indicated that under that section, Madam President, the head of the church, and what is being asked here in that specific section is that if the person or the entity is found guilty in any way, that body comes under the control of whosoever will be put in charge of the body. It means that that controller that is then seconded to the bishop or the head of the church takes over an institution that actually the head was in the first place an ecclesiastical person, not a secular controller that is asked to take control of that body. And so, as it is presently, it is a controller that takes over an ecclesiastical body. It doesn't spell well with the church. It means then, and that is the reason why I'm happy that we were able to sit down with the government, because it means, and I have used those examples just to state and to re-emphasize that the bill as it is here doesn't fit into, or the church as it is cannot fit into something of this nature. It is a creature that is foreign to the church. I want to emphasize again, Madam President, that we as a body have, and I think it is important to note, that the church feels that it must be compliant with what the country is asking for and what international agencies are asking for insofar as accountability is concerned. Of course, it goes further than accountability, I must admit. But it is important to note also, and this is the point I wish to make, that the church will support what is here before us today. But we need to go further insofar as the church is concerned. And that is the reason why, Minister Koi, I was happy that having sat down with the ministers, or the relevant ministers, that we were given the assurance as a church body that the undertaking would be there to be able to form some other legislations concerning the church, and I want to say that publicly. And I say that publicly because I have also been given permission, Madam President, by the union to remind the government that they have given undertakings in the past. And there are still some of those undertakings that are to be realized. But however, I would want to note, and perhaps to also say, that we are voting for a yes to this bill. But we could have asked for other things. We could have asked that other things be put in place before. We could have asked that we wait on the promised legislations that will be undertaken on behalf of the church, but we did not. We will agree to the bill, and we will carry the bill as it is. We could have asked for other things, but we are going in good faith. We could have asked in this Senate that the issues concerning campaign financing be a part of the undertaking here. But we're not. We're going by good faith with the undertaking that in time to come, in order to strengthen that which is before us and that which the church will be satisfied with, that that undertaking will be done in good faith. We could have asked that as a part of the undertaking today, the scrutiny of political parties and individuals politically connected through sporting organizations, that they too be a part of the whole scrutiny in a bill of this nature. But we are not. We are going by good faith. And having said all that, Madam President, the church has been given an undertaking that it is important enough that other legislations, separate and apart from what is here in this bill, be undertaken on behalf of the church. But, Madam President, I must also debunk something that has been said and has been going around the circle, that the church or churches is a high-risk grouping for money laundering and the accessibility to terrorist groups and other groupings. And I am saying, and this doesn't come from me, this comes from some of our responsible lawyers who we would have gotten advice from, that in actuality, the church is low risk insofar as money laundering is concerned. And so I just want to ensure that we put that out there. And having said all that, Madam President, it is important to note that I recognize, and it is not a matter of feeling jealous in any way, but I recognize that there are times, and I follow the news quite often, and I read both the media, electronic and print, that there are times when other views are out there and the views of other groupings are more emphasized by the media. And I've come to recognize that there are times when the church voice is not heard as much. It is important to note, and I want the media that is here to recognize that because this bill affects the church in a very salient way and affects the schools that we have responsible for in a very salient way, I want the message, I want them to assist us in getting out the message that for us as a church, it is important to recognize, again I will say, that we have some things to be ironed out in the bill. And I want to say again that I'm happy that we have had the kind of communication and dialogue in recent weeks. I wish it had been done before, but we spent many days and nights in recent times, up to last night actually, ensuring that at least some level of changes were made to the bill. And in that way, I can stand here to say that I support the bill. Thank you very much.
I recommend Senator Dr. El McKay.
Thank you, Madam President. I rise on behalf of the non-governmental organization sector, and with your permission, I'd like to refer to my notes. And before I give my comments, I just wanted to say that it was remiss of me to not mention this when I first spoke, but I am new to this process, and I just wanted to acknowledge the warm welcome that all the other senators and yourself have extended to me. I can see that, you know, everybody helps each other out, so it's nice to know. So with that, I'd like to make my comments. As an overarching statement, Madam President, our sector asserts in the very strongest of terms the collective responsibility we all assume when we take the oath as parliamentarians to do right. And we take this opportunity to underscore and highlight and reiterate that consultation, meaningful consultation, you know, the definition of consultation is to have discussions. But sometimes you can go into consultation that's, it's just token discussions. You're informed about stuff, right? So we want to highlight meaningful consultation. And actually, my own favorite word is public participation, which goes way beyond consultation. It is the real engagement of the public in decision-making and, you know, having those processes where they can really contribute to things like legislation. And so I just want to say that meaningful consultation and public participation are paramount to our work, and our sector takes that responsibility very seriously. So the way that this bill was initially handled cannot set precedent for future bills, particularly as they relate to the mutual evaluation process. Senator Koyi mentioned that this is one of the first bills that is going through as part of this mutual evaluation process. So there's going to be many more to come, and we hope that there's a lot of lessons learned here on how to proceed with those. Bad actors will attempt to dismiss our objections to lack of consultation as much ado about nothing, or even give out of context examples that malign the NPO and the NGO sector. But the truth, Madam President, is that where we are nationally is not because of non-compliance, but because there has been a lack of monitoring and enforcement from the regulators. This is a pervasive problem in a lot of our laws. The laws are beautiful, or the laws are made, but then how do we actually follow through with them? Lack of meaningful consultation and public participation in the process of making laws often renders these ineffective. When we meaningfully consult and allow space for the public participation process to take its course, that is when our laws are strongest and most effective. The truth is that many in our sector, in support of protecting Belize from those who would try to abuse our system, these references that we make to money laundering and abuse by terrorism organizations, many of us have already committed to very strict regulations and personal liabilities under existing laws. So let the record reflect clearly that the work of NGOs and NPOs has been invaluable to Belize's sustainable development, and that our response to the proposed legislation has been to make the new law as strong and as fair as it needs to safeguard those invaluable contributions. And if it is that the false premise that somehow the sector has been the one to land Belize in hot water, then, Madam President, we will be the first to call for an official inquiry in this matter. Again, let the record reflect that the Financial Action Task Force generally ranks NPOs as low risk. And while the National Risk Assessment Report of 2019, this is on the FIU website, does cite the need for specific legislation, it also highlights that lack of enforcement of existing legislation has been the issue, not necessarily compliance. These are not my words, Madam President. The Financial Intelligence Unit's own reports say as much. Having said all of that, we do take the opportunity to thank Senator Koyi and his team for their personal and professional commitment to handle the related regulations that will now need to be drafted much differently to ensure that those regulations address the matters at hand and the risk in a proportionate manner. As we like to say colloquially, and Bishop, maybe you might not like this word, but as we like to say, the devil is in the details, right? And so definitely one of the things that we're looking forward to is those details through regulation and also amendment to existing acts, for example, the MLTPA. So we are cognizant that this new law is going to have to be tested very quickly, and therefore it is imperative that the regulations that are to come meet our responsibilities to the MPOs contributing to Belize's sustainable development while meeting the requirements of the Financial Action Task Force. It would really be to the detriment of the nation if we create laws so draconian and onerous as to discourage MPOs from their good and necessary work in Belize or discourage new NPOs from forming. Many of our MPOs are also NGOs. The non-governmental organizations are really a subset of nonprofits. And many of our NGOs work closely and enjoy the trust of the international community, which is often how we get the funding and financing to be able to do the work that we do. Therefore, we can also attest that, if laws are made in such a way as to be draconian, for example, we would be sending a very mixed signal to the international community at a time when we need to bolster, not erode, confidence in Belize. Madam President, we reiterate our firm commitment to working alongside the government of Belize the National Assembly, our fellow senators, via meaningful consultation and the public participation process to create the kinds of laws we need, the kinds of laws that underscore the critical importance of partnership between the corridors of power and civil society. And so to end on a good note and on a hopeful note about how we're going to continue the process of making these regulations and the additional bills that are going to come as part of the mutual evaluation process, I'll just end by saying that none of us can go at it alone. In my professional experience, the best initiatives, the most successful initiatives have really been those in which they're collaborative. You can have meaningful discussion despite differences in view, but still be able to resolve those. So together is really the only way we can get to where we all want to go. Thank you.
I recognize Senator Herrera.
Thank you, Madam President. Madam President, I'm extremely sensitive to the sentiments expressed by my colleagues as social sector partners. I think that it's a very real issue for them. I listened to the bishop as well as Dr. Kay, and I'd also like to welcome Dr. Kay as a member of the Senate today. But I think that it's a very real issue for them, and it's certainly something that will affect them going into the future. But my presentation today, Madam President, is more to look at the recommendation of the Financial Action Task Force. That is really that is really what is driving this bill in front of us today. And if you look at the recommendation, and I took the opportunity to review them, especially there's a specific recommendation, and I think Senator Coy mentioned it, that these measures are supposed to be risk-based. In fact, if you'll allow me to read, Madam President, I'd just like to read two parts of it. Firstly, assessing risk and AML CFT policies and coordination. And that's basically referring to the anti-money laundering and the financing of terrorism, Madam President. But it said that countries should identify, assess, and understand the money laundering and terrorist financing risk for the country, and should take action, including designating an authority or mechanism to coordinate actions to assess risk. And I think that is what is happening in this bill today. And apply resources aimed at ensuring the risks are mitigated effectively. Based on that assessment, countries should apply a risk-based approach to ensure that measures to prevent or mitigate money laundering and terrorist financing activities are commensurate with the risk identified. And then I'd like to also refer to one specific to the NGOs, Madam President, and similarly, it has the risk-based approach. Countries should implement targeted financial sanctions to comply with Countries should review the adequacy of laws and regulations that relate to nonprofit organizations which a country has identified as being vulnerable to terrorist financing abuse. Countries should apply focused and proportionate measures in line with the risk-based approach to such non-profit organizations I'd like to stop there, Madam President, because I'd like to. This is basically where the issue for me comes in, because the bill is very pervasive. It's almost like a dragnet for nonprofits. And I know that Section 17 and 18, what Senator Coy said, 17 addresses the threshold, and 18, I think, addresses classes, introduces the whole concept of classes, and then Section 3 as well makes reference to the risk base. But I'm not seeing where there's an exemption, perhaps, similar to what the political parties will be benefiting from, that low risk category, where certain classes of nonprofit organizations would be exempted from this very onerous process and requirements. I think the bishop was very clear this morning. He doesn't view his church or the other religious dominations that he interacts with as high risk. In fact, I went a little further, Madam President. I went on our good friend Google, and I Googled churches, money laundering activities, and I saw two cases come up, one in Trinidad and the other one in Dominican Republic. But I haven't seen anything related to that in Belize, and this legislation is very specific to Belize. And so I'm saying, Madam President, that I think that we should follow a little more closely the recommendations of the Financial Action Task Force, which specifically recommends that the whole risk assessment be used to implement these measures. Some areas are a lot more high risk than others, and we completely agree with that. We're not, similar to what the bishop said, we're not opposed to the bill at all. We think that we need to protect our sector. We need to protect our sector and make sure that the integrity of our financial system remains intact. No issues there. But I think that there are many of these nonprofit organizations that are doing very good work in the country. And I wouldn't want us to bring in processes, and in some respects you could even call them barriers that may affect them in terms of carrying out their work. And so I think it's extremely important if we could even look a little further, and I think we all appreciate the changes that had been made from the original bill to where it is. I had checked with my partners on this side, and many of the changes that they had advocated for is being reflected here. But the risk-based part of it, Madam President, I think that the process can still be relatively cumbersome, especially to the smaller organizations. And so I think it's certainly something that we should take into account. I would like to see that we protect our whole financial system locally, but as well, work with these organizations that are having a tremendous impact on education and social services and many of the social problems that we face. And so while it's not something that is directly affecting the private sector, as much as it is affecting the other representatives here. It's certainly something that we're very sensitive of, because we realize that we're looking at a system that is highly integrated. And so while we are addressing private sector issues, there are many of the social ills that have a tremendous impact on the private sector, and we're very concerned that those continue to be addressed. And so my appeal to and I know that this is going to committee, and hopefully we could have a larger discussion in it, but I'm appealing to the government side that perhaps we could look at how we could address and maybe make it a little easier through risk assessment for the organizations that can be viewed as low risk. Thank you, Madam President.
I recognize Senator Elena Smith.
Thank you, Madam President. I'm surprised my colleague is still sitting down. Yes. Yes, I do. Madam President, please allow me to, I didn't do earlier, but welcome my colleague to the sitting today. And I trust that she is going to be, she'll have fond memories of her first day here in the Senate with us this morning. I rise, Madam President, to just make a few comments on this bill. I want to first, as the others have done, express some thanks for the discussions that were held. Notwithstanding, though, I do appreciate and support the call for better consultations, especially on these serious and important matters, and especially when it affects us. You know, we appreciate having timely consultations, as well as sufficient time to be able to properly go through these bills and make proper representations. As a union, we all know that we have always clamored for accountability and transparency. And we know that it is important that we hold organizations to account. We've never shied away from that fact. Compliance is indeed important. And so ensuring that bodies are compliant is not an issue for us, because we advocate for that. Unlike Senator Bishop here, we feel that the political parties should have been included here. If we are going to be looking at all of the possible areas of risk and all of the possible areas, where we could maybe have some of these questionable finances, right? Then we should include all those who would be seen as, right? So, Madam President, I've asked a few questions, and at this point, I don't have sufficient clarity for me to be able to properly understand the effect that this bill would have on our schools. And that is very important to me, because as we all know, the BNTU is a part of the NTUCB. In terms of our schools, we know that our schools go through the ministry where you apply, or the churches apply to operate schools, and you do that through the Ministry of Education. And I am not aware that there's any correlation between the churches having to apply as NGO or now NPO, and those schools will be listed under that application. So for us, while there may be a few schools that have been incorporated, you would understand that they would fall under this bill. But for example, the other schools that are just managed by us, by the churches, for example, how do we fall under this and what would be the implications? Because coming from within the school system, we understand the issues that we have in terms of finances for the school and being able to provide resources for our schools to operate. And we don't often get the funds that we need to operate from the churches who manage us. That's the reality. And therefore, as schools, we have to do our own fundraising to be able to have our resources. And so that is the concern now. How is that going to impact, these things that we do as schools? What would be the implications for us? How would it impact our schools? And for the most part, Madam President, and I can speak specifically for our primary schools, for example, when we do our RAGS Day, you collect what? Depending on your school size, $50, $100, $200, whatever that may be. It's not substantial amount. And it is clear where those come from. When we do get, for the most part, when we do get donations of any kind from any international group or any other group, a lot of times it's in kind and not necessarily cash. You would see them go and put up a playground in their schoolyard, you would get books. But if we are saying that the churches manage these schools and as such these schools would form a part or would fall under this, then I am concerned, as I said, about the impact that it will have and the ability of our schools to be able to properly function, and then the further impact it would have on our teachers who continue to take out of pocket to provide resources for their classrooms and for the schools. What impact that would have on what we do or what we normally do as teachers. So for me, I need to get that clear distinction or that clear understanding as to the impact on this bill, specifically on those schools that have not been incorporated. So I'm talking about the regular schools. Again, while we understand that compliance is important, there is a system in place where our schools, our managements should be going through and assessing and evaluating and monitoring the school finances and ensuring that those administrators do account for the school finances. So there's a mechanism in place. When we look at if there is an issue and somebody has to come in and take over and address those things, again, what would be the impact of that on schools? Because if I am going to be having somebody who has no experience in terms of my system, then what would be the impact of that? If somebody has to come and take over because we have been non-compliant, for example, then what would be the impact on our schools? So for me, we don't have that clear understanding. We are being told that it won't impact schools, but we are being told, yes, schools are going to be impacted. So I need to get that very clearly. We have to also ensure that as we move this process forward, that we provide the proper resources and support that the work can happen and can happen in a timely basis. So if I have to be monitoring, if there is an entity that I feel has not been compliant and is at risk or is putting us at risk as a nation, then we must have the proper resources in terms of human and otherwise to be able to quickly do what we must do to address those situations. I agree, Madam President, that there should be some exception. We've seen oftentimes that there are exceptions to the rules. And for not just because you want to exclude persons, but because there are legitimate reasons why there can be exceptions. And I do believe in this case, that schools should be an exception. If it is, that schools will fall under this NPO. And so I will reiterate our position that we fully support compliance, we fully support being accountable, we fully support transparency, because we don't want to have issues that will put a black eye on the country. We are aware of that and we fully support that. But I need to get those explanations, those ways in which I can feel satisfied that I fully understand what will be the impact on our schools, if any, so that we would know how to address those. Thank you, Madam President.
Madam President, I rise to wind up the debate on a non-profit organization bill, and I have indicated to all the senators that the bill will go into committee, and the director of the Financial Intelligence Unit is here and will be available to respond to the questions that have been posed. Madam President, I do not intend to get into any blaming, nor will I get into any casting any aspersion as to which organization is money laundering or is financing terrorism. All of that is available on the internet. Like Senator Herrera, when I listened to the bishop, I Googled churches money laundering. I expected to get a blank page. It wasn't a blank page. 2021, cardinals, bishops from the Vatican, where the Pope lived, criminally indicted for money laundering. Next story, non-traditional church in Guatemala used to launder the proceeds of drug trafficking. I repeat, the issue here is not whether the church, whether a school, whether any non-profit organization is involved in money laundering, financing of terrorism. My mind went back to Sanctuary Bay. Central to Sanctuary Bay was something called City River Wildlife Reserve, a non-profit, totally unregulated. I refer to these things to set a context. There is real risk out there. Whilst this is being rushed, while this is being forced on us at this time, it is in response to risk that exists within Belize and outside Belize. Now, there has been criticism, some legitimate, about a lack of consultation and insinuations cast about genuine and sincere consultation. I don't know whether the consultation that the government committee conducted and Senator Cowie conducted was not genuine. I don't know what was the necessity for that insinuation. But we have a bill that has multiple amendments as a result of what we believe is a good faith, genuine consultation process. But I checked with the director, because it is important when we make allegations and criticisms that we understand where the hat fits and who should wear the hat. The director, who will come into committee, so you can double check, confirmed to me that not one, not two, but 3 consultation sessions were held with the NGO, nonprofit sector on the policy that underpins this bill and what would be contained in the bill, what was driving it. 3 sessions were held prior to the bill coming to the National Assembly. Who gone? I don't know. Who never gone? I don't know. But it should not be propagated and disseminated that there was no consultation. The sector that is affected was consulted by the FIU as to the policy underpinning this bill. All the senators in the social partner have recognized and have thanked the government for the consultations that took place once the bill was tabled. We are here today discussing multiple amendments as a result of that process. So, damn when we not do it, damn when we do it. Madam President, members of the Senate, the public needs to get a picture. The sky is not falling. No church won't close down. No school won't stop operate because of this bill. The impression being given to the public, and I recall not Senator Kay, but the substantive senator for the non-governmental organizations, alarmist reaction when the bill came to the House. I was stunned when I looked on this bill. Clause 4 says, this is what the register must have. The name and address, telephone number and email address of the non-profit organization. Purposes and activities, identity of every person who owns, controls, or directs the non-profit, the date of its registration, such other information as the NPO registrar considers appropriate. Who are you? Where your address there? Where your name? Who are the people involved? This is not some attempt to get into the business of the nonprofit, because the law goes on very clearly to say this information is to be publicly available. Anybody who wants to know which NGO is out there, which nonprofit is out there, it will be publicly available. Who are the people behind it? And if anybody wants to hide that information, they will not be registered in Belize. Anybody who doesn't want to tell us who is behind the nonprofit will not be registered in Belize. Any nonprofit that doesn't have an address will not be registered in Belize. When you hide that type of information, there is a presumption that you're a double. Importantly, any information received pursuant to the provisions of this Act on the affairs of a non-profit organization, other than the publicly available information, shall not be disclosed. So, senators, the registrar has the power to inspect, request information, seek disclosure, to understand what the NGO is doing. And that information will not be disclosed. Public register, who you are and what you are doing. If there's reason for the registrar to find out more, that is information that will not be disclosed. And I do not believe that there is any nonprofit in this country, whether it be a church, whether it be an environmental organization, whether it be a health organization, whether it be a religious organization, whether it be a charitable organization that is not involved in money laundering and terrorism financing, will have a problem with that. If you are not breaking the law, why do you want to keep your activities secret from a registrar who cannot disclose what your activities are? Now, I want to make a point that was a response to the point raised by Senator Herrera. First of all, Senator, and I ask you to get details when the director comes in, Belize is currently undergoing a risk assessment. And so your references to clause 16 and 17 and how onerous they are have to be seen in the context of the regulations that are to come. The regulations will set the threshold so as to say only above a certain limit will be caught by those provisions. Thereby, after the assessment of the risk, then you know that churches, for example, only churches that have membership of a certain amount or have accounts with a certain amount of money in there need to do further, there needs to be further due diligence. I use churches as an example, but it would apply to any non-profit. The point of the matter is this. You are correct in saying that without regulations and without thresholds, that those provisions will be onerous, but the regulations will be put in place to ensure that only those who jump over a certain risk-based threshold will be required to do more in terms of reporting and being available for inspection by the registrar. But it is critically important, Madam President and members of the Senate, for us to recall that the bill simply requires nonprofits who are doing legitimate and legal business in Belize to file a simple annual return. There is no requirement, for example, for audits. So, to wind up, there has been consultation. The consultation by the government has been genuine. Senator Cowie explained to the Senate the threat to the economy and the financial sector of this country if we do not pass the review by the Financial Action Task Force. And senators, Senator Perfeet will recall this, and Senator Bev, December 2017, a very similar thing happened. You see, Senator, to shake your head. Legislation after legislation after legislation was rushed in order to meet the requirements and the deadlines. And none of us are happy, neither that side or this side, in happy in doing it that way. We had over 10 bills in cabinet yesterday. Not happy, but they have to be passed. They have to be brought into force by June. And so we will come back to the Senate with a whole slew of legislation to be considered. The point I'm making simply is that we have to improve the way in which this review and the satisfaction of the criteria is done. I think that's agreed. The nonprofit bill will not place any undue burden on that sector. But there must be provisions in law to enable the registrar to do what is necessary. There is one other clause I wanted to refer to because the public would get the impression that the sky is falling and that this is an extremely dangerous piece of legislation. Clause 13. Madam President, it says, subject to subsection 2, the registrar may inquire into any issue concerning the operations of a nonprofit, including its purposes, administration, and management, its source or application of funds, or other property received or distributed. That is very wide and very empowering. But subsection 2 says, an inquiry referred to in subsection 1 may be carried out for the purpose of investigating any nonprofit which the NPO registrar has reasonable grounds to suspect the nonprofit organization has committed an offense under the Money Laundering and Terrorism Act or any other law in which contravention may constitute wrongdoing on the part of a nonprofit. So that the power of inspection, that an inquiry that the registrar has, he must have reasonable grounds to do it. So, Madam President, the position is this. We have given a written undertaking to the church, and Senator Bengoshe and other members of this Senate, you were reminded about other people giving undertakings. I would suggest to you, Senator Bengoshe, check the track record of this government in undertakings given to the church. We will fulfill the obligation and undertaking given to the church. We firmly say that the non-profit organizations in Belize that are conducting legitimate business have nothing to fear by this legislation. We say to the non-profit sector, you play an important role in the development of this country, and we want to continue to cooperate and welcome non-profits for the work that they do across many spheres of activities in Belize. We do appeal, however, for registration and annual reports being filed, and an understanding that the powers in here conferred on the registrar is to try as best as may be to avoid another sanctuary bay. I ask that the question be put, Madam President.
Honorable members, the question is that a bill for an act to provide for the regulation of the non-profit organizations to protect non-profit organizations from terrorist financing abuse, to satisfy the requirements of the Financial Action Task Force recommendations with respect to laws regarding combating the financing of terrorism, and to provide for matters connected therewith or incidental thereto, be read a second time. All those in favor, kindly say aye.
Aye.
Those against, kindly say no. The ayes have it.
Bill for an act to provide for the regulation of non-profit organizations to protect NPOs from terrorist financing abuse, to satisfy the requirements of the Financial Action Task Force recommendations with respect to laws regarding combating the financing of terrorism, and to provide for matters connected therewith or incidental thereto. Committee of the Whole Senate on Bills.
Honorable members, in accordance with Standing Order 54, the Senate will now resolve itself into the Committee of the Whole Senate to consider the bills that were read a second time. Honorable members, I will now take the chair as the chairperson of the Committee of the Whole Senate. I will ask for the gallery to be cleared.
Reporting and third reading of bills.
I recognize the Leader of Government Business.
Madam President, I rise to report that the Committee of the Whole Senate has considered the Senior Courts Amendment Bill 2023 and passed it without amendment. I now move that the bill be read a third time.
Honorable members, the question is that the bill for an act to amend the Senior Courts Act, Act number 27 of 2022 of the substantive laws of Belize to remove provisions relating to the assignment of attorneys at law by the court to provide legal aid services and to provide for matters connected therewith or incidental thereto be read a third time. All those in favor, kindly say aye. Aye. Those against, kindly say no. The ayes have it.
Bill for an act to amend the Senior Courts Act, Act number 27 of 2022 of the substantive laws of Belize to remove provisions relating to the assignment of attorneys at law by the court to provide legal aid services and to provide for matters connected therewith or incidental thereto.
I recognize the Leader of Government Business.
Madam President, I rise to report that the Committee of the Whole Senate has considered the Legal Aid Bill 2023 and passed it with amendment.
Honorable members, the question is that the bill for an act to make legal aid readily available to persons of small or moderate economic means to enable the cost of providing legal aid granted to persons of small and moderate economic means to be defrayed wholly or partly out of money provided for the purpose by the National Assembly and to provide for matters connected therewith or incidental thereto as amended be read a third time. All those in favor, kindly say aye. Aye. Those against, kindly say no. The ayes have it.
Bill for an act to make legal aid readily available to persons of small or moderate economic means to enable the cost of providing legal aid granted to persons of small and moderate economic means to be defrayed wholly or partly out of money provided for that purpose by the National Assembly and to provide for matters connected therewith or incidental thereto.
I recognize the Leader of Government Business.
Madam President, I rise to report that the Committee of the Whole Senate has considered the Non-Profit Organizations Bill 2023 and passed it with amendment. I now move that the bill be read a third time.
Honorable members, the question is that the bill for an act to provide for the regulation of non-profit organizations to protect non-profit organizations from terrorist financing abuse to satisfy the requirements of the Financial Action Task Force recommendations with respect to laws regarding combating the financing of terrorism and to provide for matters connected therewith or incidental thereto as amended be read a third time. All those in favor, kindly say aye. Aye. Those against, kindly say no. The ayes have it.
Bill for an act to provide for the regulation of NPOs to protect NPOs from terrorist financing abuse to satisfy the requirements of the Financial Action Task Force recommendations with respect to laws regarding combating the financing of terrorism and to provide for matters connected therewith or incidental thereto.
I recognize the Leader of Government Business.
Madam President, I move that the Senate do now adjourn.
Honorable members, the question is that the Senate do now adjourn. All those in favor, kindly say aye. Aye. Those against, kindly say no. The ayes have it. The Senate now stands adjourned.